Civil Procedure Code (CPC). The substantial part of the Code of Civil Procedure contains 158 sections. The first schedule comprises 51 orders and rules providing procedure. Appendices contain model forms of pleading, process, decree, appeal, execution proceedings. Section 1 to 8 are preliminary in nature. Section 1 provides for commencement and applicability of this code. Section 2 is the definition clause and a sort of statutory dictionary of important terms used in the body of the code. Section 3 to 8 deal with the constitution of different types of courts and their jurisdiction. Part 1, Section 9 to 35B. Section 9 to 35B, Part 1, and Orders 1 to 20 of the first schedule deal with suits. Section 9 enacts that a civil court has jurisdiction to try all suits of civil nature unless they are barred expressly or impliedly. Whereas Section 10 provides for stay of suit, res sub judice, and Section 11 deals with the well-known doctrine res judicata. Section 13 and 14 relate to foreign judgments. Section 15 to 21A regulate the place of suing. They lay down as to the jurisdiction of courts and objections as to jurisdiction. Section 22 to 25 make provisions for transfer and withdrawal of suits, appeals, and other proceedings from one court to another. Orders 1 to 4 deal with institution and framing of institution and framing of suits, parties to the suit, and recognized agents and pleaders. Order 5 contains provisions as to issue and service of summons. Order 6 deals with pleadings. Order 7 and 8 deal with plaint, written statement, set-off, and counterclaim. Order 9 requires parties to the suit to appear before the court and enumerate consequences of non-appearance. It also provides the remedy for setting aside an order of dismissal of the suit of a plaintiff for non-appearance and of setting aside an ex parte decree against a defendant for non-appearance. Order 10 enjoins the court to examine parties with a view to ascertaining matters in controversy in the suit. Order 11 to 13 deal with discovery, inspection, and production of documents and also admissions by parties. Order 14 requires the court to frame issues, and Order 15 enables the court to pronounce judgment at the first hearing in certain cases. Order 16 to 18 certain provisions for summoning, attendance, and examination of witnesses and adjournments. Order 19 empowers the court to make an order to prove facts on the basis of an affidavit of a party. Section 75 to 78, Part 3, and Order 26 make provisions as to issue of commissions. Section 94 and 95, Part 6, and Order 38 provides for arrest of a defendant and attachment before judgment. Order 39 lays down the procedure for issuing temporary injunction and passing interlocutory orders. Order 40 deals with appointment of receivers. Order 25 provides for security for costs. Order 23 deals with withdrawal and compromise of suits. Order 22 declares effect of death, marriage, or insolvency of a party to the suit. After hearing is over, the court pronounces a judgment. Section 33 and Order 20 deal with judgment and decrees. Section 34 makes provision for interest. Section 35, 35A, 35B, and Order 20A deal with costs. Part 4, Parts 4 and 5, Section 79 to 93, and Orders 27 to 37 lay down procedure for suits in special cases, such as suits by or against government or public officers, Section 79 to 82 and Order 27, suits by or against aliens, foreign rulers, ambassadors, and envoys, Sections 83 to 87B, suits by or against soldiers, sailors, or airmen, Order 28, suits by or against corporations, Order 29, suits by or against partnership firms, Order 30, suits by or against trustees, executors, administrators, Order 31, suits by or against minor, lunatic, and persons of unsound mind, Order 32, suits relating to family matters, that is Order 32A, suits by indigent persons or paupers, that is Order 33, suits relating to mortgages, that is Order 34, interpleader suits, that is Order Section 88 and Order 35, friendly suits, that is Section 90 and Order 36, summary suits, that is Order 37, suits relating to public nuisances, that is Section 91, and suits relating to public trust, that is Section 92. Section 89, as inserted from 1st July 2002, provides for settlement of disputes outside the court through arbitration, conciliation, mediation, and lok adalats, that is Section 89 for ADR. Part 7 and 8, Sections 96 to 115 and Orders 41 to 47 contain detailed provisions for appeals, reference, review, and revision. Section 96 to 99A, Order 41 deal with first appeals. Section 100 to 103 and Order 42 discuss law relating to second appeals. Section 104 to 108 and Order 43 contain provisions as to appeals from orders. Section 109, 112 and Order 45 provide for appeals to the Supreme Court. Order 44 enacts special law concerning appeals by indigent persons or paupers. Section 113 and Order 46 pertain to references to be made to a High Court by a subordinate court when a question of constitutional validity of an act arises. Sections 114 and Order 47 permit review of judgments in certain circumstances. Section 115 confers revisional jurisdiction on High Courts over subordinate courts. Part 2, Section 36 to 74 and Order 21 cover execution proceedings. The principles governing execution of decrees and orders are dealt with in Section 36 to 74 substantive law and Order 21 procedural law. Order 21 is the longest order covering 106 rules. Part 10, Sections 121 to 131 enables High Courts to frame rules for regulating their own procedure and procedure of civil courts subject to their superintendence. Part 11, Sections 132 to 158 relate to miscellaneous proceedings. Explanation to Section 141 as added by the Amendment 76 clarifies that the expression proceedings would not include proceedings under Article 226 of the Constitution. That is writ in High Court. Section 144 embodies the doctrine of restitution and deals with the power of the court to grant relief of restitution in case of a decree set aside and modified by a superior court. Section 148 A, as inserted by the CPC Amendment 76, is an important provision which permits a person to lodge a caveat in a suit or a proceeding instituted and about to be instituted against him. It is the duty of the court to issue notice and afford an opportunity of hearing to a caveator to appear and oppose interim relief sought by the applicant. Sections 148 to 153A confer inherent powers in every civil court. Section 148 enables the court to enlarge time fixed or granted by it for doing any act. Section 149 authorizes the court to permit a party to make up deficiency of court fees on plaint, memorandum or appeal. Section 151 is a salutary provision. It saves inherent power in every court to secure the ends of justice and also to prevent the abuse of process of the court. Section 152 to 153A empower a court to amend judgments, decrees, orders and other records arising from accidental slip or omission. Section 153B, as added in Amendment 76, expressly declares that the place of trial shall be open to public. The proviso, however, empowers the presiding judge, if he thinks fit, to order that the general public or any particular person shall not have access to the court. That is summary of the code.